Welcome to C Learning on the General Data Protection Regulation. This course... As part of you are carrying out this course because you have a role in either using or implementing personal information systems as part of your job and should do so in accordance with the new UK General Data Protection Regulations. Should you have accessibility issues, all text can be read by a screen reader and the text is vocalised by the presenter or voiceover in most cases. Welcome to C Learning on the General Data Protection Regulation. This course covers the 12 steps as outlined by the Information Commissioner's Office to get ready for the regulation. The e-learning demonstrates what steps are needed as well as giving practical advice as to what to do. It will last 60 minutes and there'll be a quiz at the end to test your knowledge. As of May 2018, the DPA will be replaced by the General Data Protection Regulation, or GDPR, with the aim of harmonising data protection laws across the EU. This updated set of rules will take into account modern globalisation and the ever-changing technology landscape. Unlike the DPA, the GDPR was made by the European Parliament and Council and will therefore apply to any company processing personal data of individuals in the EU. Significant penalties can be imposed on employers who breach the GDPR, including fines of up to €20 million or 4% of a company's turnover, whichever is the larger. They are designed to strongly penalise any employers who show a disregard for the security of personal data. The question we need to ask at this stage is what can you do now as an employee, manager or owner to prepare for the GDPR? We're going to guide you through the 12 key steps as outlined by the Information Commissioner's Office to ensure you are prepared. At the end of the programme, we shall provide links to the ICO's printable checklist and other resources to help implement the regulation. Awareness. You should make sure the decision makers and key people in your organisation are aware the law is changing to the GDPR. They need to appreciate the impact this is likely to have. The more eyes and ears looking out for compliance within your organisation, the better. You can also identify and make known in the business those areas that could cause compliance problems under the GDPR. It would be useful to start by looking at your organisation's risk register, if you have one. A risk register is a data store, usually a spreadsheet or database, which details potential privacy risks, who is responsible for the associated management of the risk, and what is done to control the risk and the effect of its control. Risk is usually measured in terms of likelihood and impact, to give a combined overall score when multiplied together. Risk equals severity times likelihood. Both the residual risk, the initial risk level, and the current risk, as a result of implementing controls, should be recorded in the register. Building a risk register from scratch could have significant resource implications, especially for larger and more complex organisations. You may find compliance difficult if you leave such preparations until the last minute. Information you hold. You should document what personal data you hold, where it came from, and who you share it with. You may need to organise an information audit across the organisation or within particular business areas. The GDPR requires you to maintain records of your processing activities. It updates rights for a networked world. For example, if you have inaccurate personal data and have shared this with another organisation, you will have to tell the other organisation about the inaccuracy so that it can correct its own records. You won't be able to trace information that needs to be changed unless you know what personal data you hold, where it came from, and who you share it with. You should document this. Doing this will also help you to comply with the GDPR's accountability principle, which requires organisations to be able to show that they comply with the data protection requirements. Effective policies and procedures are a good way of showing compliance with this information requirement. Communicating privacy information. You should review your current privacy notices and put a plan in place for making any necessary changes in time for GDPR implementation. When you collect personal data, you currently have to give people certain information, such as your identity and how you intend to use their information. This is usually done through a privacy notice. Under the GDPR, there are some additional things that you have to tell people. For example, you will need to explain your lawful basis for processing the data, your data retention periods, and that individuals have a right to complain to the ICO if they think there is a problem with the way you are handling their data. So what does this look like in real life? On web forms, the ICO recommends one of two methods. Layering, where the information is given to the user in various layers. Just in time, where the information is provided by hovering over fields. Layering. This is an example of layering where the user can click on the drop-down menu item, first layer, read the notice, second layer, and click on a link for a hyperlink to the full privacy policy. Just in time. These privacy notices explain how the data is going to be used on a field-by-field basis, just in time, when the user engages with each field. Not only should these notices be provided, they should also be in concise, easy to understand and clear language. Check that no jargon or overly elaborate English is used. Further examples from the ICO can be found here. You should check your procedures to ensure that they cover all the rights individuals have, including how you delete personal data or provide data electronically and in a commonly used format. The GDPR includes the following rights for individuals. The right to be informed. The right of access. The right to rectification. The right to erasure. The right to restrict processing. The right to data portability. The right to object. And the right not to be subject to automated decision-making, including profiling. On the whole, the rights individuals will enjoy under the GDPR are the same as those under the DPA, but with some significant enhancements. Again, if you are geared up to give individuals their rights now, then the transition to the GDPR should be relatively easy. This is a good time to check your procedures and to work out how you would react if someone asked to have their personal data deleted, for example. Ask yourself as to whether your systems can be used to locate and delete the data, and who will make the decisions about the deletion. These procedures should be recorded and those persons responsible made aware of their presence. The right to data portability is new. Data portability is the ability to move data from one system to another in a commonly recognizable format. Examples would include the ability for data from Facebook to talk to other applications, such as Instagram, etc. From a technical standpoint, this may consist of a common XML data structure or simply a CSV file. Any data must be provided without undue delay and within 1 month. This can be extended by 2 months, where the request is complex or you receive a number of requests. You must inform the individual within 1 month of the receipt of the request and explain why the extension is necessary. It only applies to personal data an individual has provided to a controller, whether processing is based on the individual's consent or for the performance of a contract, and when processing is carried out by automated means. You should consider whether you need to revise your procedures and make any technical changes. You will need to provide personal data in a structured, commonly used and machine-readable form and provide the information free of charge. You should update your procedures and plan how you will handle requests from data subjects for their personal data. As we have said before, you should aim in most cases not to charge for requests, but you can refuse or charge for requests that are manifestly unfounded or excessive. If you refuse a request, you must tell the individual why and that they have the right to complain to the supervisory authority and to a judicial remedy. You must do this without undue delay and at the latest within 1 month. The European Data Protection Board, EDPB, will resolve any disputes. Note that you'll have a month to comply rather than the current 40 days under the Data Protection Act. Policies, procedures and your privacy notice should be updated to take care of this fact. If your organisation handles a large number of access requests, consider the logistical implications of having to deal with requests more quickly. You could consider whether it is feasible or desirable to develop systems that allow individuals to access their own information easily online. Consideration should be given to the overall security of such systems, with privacy by design being the dominant principle applied when building such systems. You should identify the lawful basis for your processing activity in the GDPR, document it, and update your privacy notice to explain it. The lawfulness of the processing conditions usually comprises of the fact that the data subject has given their consent. There are, however, other reasons such as processing the data is necessary for the purposes of a contract or in order to protect the interests of the data subject. Consult sections 6 and 9 of the legislation for information about specific cases. Note that the lawful bases in the GDPR are broadly the same as the conditions for processing in the DPA. It should be possible to review the types of processing activities you carry out and to identify your lawful basis for doing so. You should document your lawful basis in order to help you comply with the GDPR's accountability requirements. You'll also have to explain your lawful basis for processing personal data in your privacy notice when you answer a subject access request. Many organizations will not have thought about their lawful basis for processing personal data. Under the DPA, this does not have many practical implications. However, this is different under the GDPR because of some individuals' rights will be modified depending on your lawful basis for processing their personal data. The most obvious example is that people will have a stronger right to have their data deleted where you use consent as your lawful basis for processing. Consent. You should review how you seek, record and manage consent and whether you need to make any changes. Refresh existing consents now if they don't meet the GDPR standard. Consent must be freely given, specific, informed, unambiguous, and above all there must be a positive opt-in. A positive opt-in means that the user must actively press a button, checkbox, or sign a piece of paper to give consent. It cannot be inferred from silence, leaving pre-ticked boxes pre-ticked, or simple inactivity. It must also be separate from other terms and conditions, and you'll need to have simple ways for people to withdraw consent. Public authorities and employers will need to take particular care. Consent has to be verifiable, and individuals generally have more rights when you rely on consent to process their data. You are not required to automatically repaper or refresh all existing DPA consents in preparation for the GDPR. But if you rely on individuals' consent to process their data, make sure it will meet the GDPR standard on being specific, granular, clear, prominent, opt-in, properly documented, and easily withdrawn. For instance, if you're going to collect contact information in a number of ways, email, phone, etc., or for a number of bodies, company, parent company, or third-party organizations, be careful not to bundle consent together into a single checkbox. Instead, separate them out as shown. Some organizations also allow the removal of consent. Here is an example from The Guardian. Children. You should start thinking now about whether you need to put systems into place to verify individuals' ages and to obtain parental or guardian consent for any data processing activity. For the first time, the GDPR will bring in special protection for children's personal data, particularly in the context of commercial internet services such as social networking. If your organization offers online services, information societal services, to children and relies on consent to collect information about them, then you may need a parent or guardian's consent in order to process their personal data lawfully. The GDPR sets the age when a child can give their own consent to this processing at 16, although this may be lowered to a minimum of 13 in the UK. If a child is younger, then you'll need to get consent from a person holding parental responsibility. This could have significant implications if your organization offers online services to children and collects their personal data. Remember that consent has to be verifiable, and that when collecting children's data, your privacy notice must be written in language that the children will understand. Data breaches. You should make sure you have the right procedures in place to detect, report and investigate a personal data breach. Some organisations are already required to notify the ICO and possibly some other bodies when they suffer a personal data breach. The GDPR introduces a duty on all organisations to report certain types of data breach to the ICO and in some cases to individuals. You only have to notify the ICO of a breach where it is likely to result in a risk to the rights and freedoms of individuals. If, for example, it could result in discrimination, damage to reputation, financial loss, loss of confidentiality, or any other significant economic or social disadvantage. An extreme example of an organisation which would have needed to notify would be Ashley Madison, an extramarital affair dating site. Publication of the members' list left the members open to blackmail, social embarrassment, and the end of many marriages. Contrasting this with people who sign up for free Wi-Fi in a pub, a breach of that information, although potentially valuable to hackers, is not notifiable to the ICO. This applies to any company with a services supplementary to the primary activity of the business, in this case, serving alcoholic beverages and food. Where a breach is likely to result in a high risk to the rights and freedoms of individuals, as in the case of Ashley Madison, you will also have to notify those concerned directly in most cases. You should put procedures in place to effectively detect, report and investigate a personal data breach. You may wish to assess the types of personal data you hold and document where it would be required to notify the ICO or affected individuals if a breach occurred. Large organisations will need to update policies and procedures for managing data breaches. Failure to report a breach when required to do so can result in a fine, as well as a fine for the breach itself. Data protection by design and data protection impact assessments. It has always been good practice to adopt a privacy by design approach. Privacy by design means that privacy and data protection is considered from the start of the design of any system and not just bolted in at the end. A privacy impact assessment, PIA, is carried out as part of this process. However, the GDPR makes privacy by design an express legal requirement under the term data protection by design and by default. It also makes PIAs, referred to as data protection impact assessments or DPIAs, mandatory in certain circumstances. A DPIA is required in situations where data processing is likely to result in high-risk individuals. For example, where new technology is being deployed, where profiling operation is likely to significantly affect individuals, or where there is processing on a large scale of the special categories of data. If a DPIA indicates that the data processing is high risk and you cannot sufficiently address those risks, you will be required to consult the ICO to seek his opinion as to whether the processing operation complies with the GDPR. You should therefore start to assess the situations where it will be necessary to conduct a DPIA. Who will do it? Who else needs to be involved? Will the process be run centrally or locally? Data protection officers. You should consider whether you are required to formally designate a Data Protection Officer, or DPO. You must designate a DPO if you are a public authority, except for courts acting in their judicial capacity, an organisation that carries out the regular and systematic monitoring of individuals on a large scale, or an organisation that carries out the large-scale processing of special categories of data, such as health records or information about criminal convictions. It is most important that someone in your organisation or an external data protection advisor takes proper responsibility for your data protection compliance and has the knowledge, support and authority to carry out their role effectively. You may also need to carry out a Privacy Impact Assessment, PIA, under Article 33 of the GDPR. PIAs, as we've seen before, help companies identify and minimise privacy risks with new projects. It overlaps with other organisational processes such as risk management and project management and result in a PIA report. International. If your organisation operates in more than one EU member state, you should determine your lead data protection supervisory authority and document this. The lead authority is the supervisory authority in the state where your main establishment is. Your main establishment is the location where your central administration in the EU is, or else the location where decisions about the purposes and means of processing are taken and implemented. This is only relevant where you carry out cross-border processing, i.e. you have establishments in more than one EU member state, or you have a single establishment in the EU that carries out processing which substantially affects individuals in other EU states. If this applies to your organisation, you should map out where your organisation makes its most significant decisions about processing activities. This will help to determine your main establishment and therefore your lead supervisory authority. So let's refresh our knowledge of what we have learnt so far by getting ready for the GDPR. You've learnt about these 12 steps to successful implementation. Step 1. Awareness. You should make sure that decision makers and key people responsible for personal data in your organisation are aware that the law is changing to the GDPR. They need to appreciate the impact this is likely to have. This could be by using awareness training or another similar method. Step 2. Auditing the information you hold. You should document what personal data you hold, where it came from, and who you share it with. You may need to organise an information audit. Step 3. Communicating privacy information. You should review your current privacy notices and put a plan in place for making any necessary changes in time for GDPR implementation. Step 4. Individuals' rights. You should check your procedures to ensure they cover all the rights individuals have, including how you would delete personal data or provide data electronically in a commonly used format. Step 5. Subject access requests. You should update your procedures and plan how you will handle requests within the new timescales and provide any additional information. Step 6. Lawful basis for processing personal data. You should identify the lawful basis for your processing activity in the GDPR, document it, and update your privacy notice to explain it. Step 7. Consent. You should review how you seek, record and manage consent and whether you need to make any changes. Refresh existing consents now if they don't meet the GDPR standard. Step 8. Children. You should start thinking now about whether you need to put systems in place to verify individuals' ages and to obtain parental or guardian consent for any data processing activity. Step 9. Data breaches. You should make sure you have the right procedures in place to detect, report and investigate a personal data breach. Step 10. Data protection by design. Privacy and data protection should be considered from the start of the design of any system or process and not just bolted in at the end. A privacy impact assessment or PIA may also need to be carried out as part of this process. Step 11. Data protection officers. You should designate someone to take responsibility for data protection compliance and assess where this role will sit within your organisational structure and governance arrangements. You should also consider whether you are required to formally designate a data protection officer. Step 12. International. If your organisation operates in more than one EU member state, i.e. you carry out cross-border processing, you should determine your lead data protection supervisory authority. The Information Commissioner's Office, or ICO, have produced a handy checklist that complements the 12-step advice offered in this training. Use the checklist to help you identify and map out what parts of your business need attention. Links to this and other useful guidance documentation are available at the end of the training. Now you have an understanding of the GDPR, you'll realise that there are further steps to take to ensure that your entire company is prepared for this new legislation. Firstly, there is training. Remember, this course is 100% free to download and use. Should you wish to customise it, purchase an online authoring system called Jacked or Cloud. Contact us and we can set you up to do this in minutes. Additional awareness training will also be needed. We've compiled a list of subject areas from our course list of over 150 courses. Self-assessment. It is important to assess your company's readiness for the GDPR. The ICO offers a useful checklist designed to help you get your house in order. The Getting Ready for the GDPR checklist includes getting to grips with the new rights of individuals, subject handling access requests, consent, data breaches, and designating a data protection officer. In addition, we offer a variety of guided self-assessment tools aimed at all businesses from SMEs to global corporations. These systems have added advantages and they provide solutions and consultancy to help secure IT infrastructure and automate tasks such as subject access requests. Contact eLearning WB about training, course customization, and any additional awareness e-learning requirements you may have. Remember, if you are already compliant with the DPA, then there is not much to do, but don't be complacent. The differences are significant, and as we have seen, failure to comply can be catastrophic, with fines consisting of whatever is the largest of either 4% of annual turnover or 20 million euros. We hope to hear from you soon should you require help with training and assessment. Failing that, then we wish you good luck with your efforts in meeting the challenges thrown forward by this valuable and timely legislation.